Mr. Mendez, can you hear me?
I can now, Your Honor. Good afternoon.
Very good. Good afternoon. And
I don't know if they are supposed to hear where that speaker. It's not working.
Mr. Mendez, would you please speak for a moment?
Yes, sir. Good afternoon again. Thank you for allowing me to appear by Zoom.
I can hear it, and if it becomes a problem, I'll advise, but I can hear it.
Okay, you're probably hearing him off my tablet.
I'm hearing him somewhere from
I
the
think it's that.
Maybe it is.
No, I don't think so. Mr. Mendez,
Yes, sir.
give us a 5 count. Count to 5 forwards and backwards.
1, 2, 3, 4, 5. 5, 4, 3, 2, 1.
Yeah, you see, that's not coming out. We're trying to get you on the right speakers here.
I can hear you
Stand by one
perfect.
moment.
I can hear Your Honor. I couldn't hear the ladies.
Right.
Oh, so my mic's not working.
The speakers,
Yeah,
microphone.
I didn't hear them either.
Which is that?
I'm assuming it's that one.
And speakers. What is the TV? The TV is not there.
I don't know, that's what I don't know what. It could be.
Hello?
Yes, sir.
Ladies, say something.
Good afternoon.
Could you hear that?
Not with great audio, but I could hear it. I can certainly advise the court when I have difficulty hearing.
Okay, let's leave it at that. And you ladies can hear from here.
Should I move this mic closer? Would that help?
Is that connected
I don't
on?
think they're connected anymore because
Yeah.
it's such a big feedback.
I'm gonna have to come in one of these days and we're gonna have to play TV set to do this multi-mode.
This,
Yeah, see, it's coming out down there. I don't, excuse me, Mr. Mendez, I hate to take any more of your time.
No,
Give me
sir.
1 second.
Thank you.
Yeah. Digital audio out. Is going where? Oh, to the sound bar.
and it won't work.
Well,
That's what I was playing with earlier. It wouldn't.
hello?
Yes, sir.
I see that's not coming out either. No, go back, let's see what's in that Dropbox then. Same system. No, it's just not there. We will have to. Well, then, oh, I get it. All right, well, when we get done here, remind me to plug that back in.
Okay, will you fix that camera back?
I'm sorry,
Will you fix that camera back?
what did I do?
Can't see the ladies.
Oh, yeah. Is that good enough?
Good for me, if it's good for y'all.
Okay, we will muddle through like this. And, okay, who is this court reporter and why are they here?
Judge, our judge down here wanted to have I guess, a copy of the proceedings as to what would transpire so I could report back. So we have requested the court reporter to transcribe the proceedings for the Miami court.
Well, and do we know where that person is?
Claudia is on. There she is.
There she is. Okay. Okay. So we have Ms. Bauhan.
It's Bond.
Bond, okay, I'm sorry. And Ms. Bond's attorney, who is Ms. Cox Brakefield.
That's correct, Your Honor. Kathy Cox Brakefield.
And we have Mr. Mendez, who is here as the representative of the estate of Grover Larkins Jr.
Yes, sir.
Okay, I hope that, Mr. Mendez, you'll excuse me, that I'm gonna spend most of my time looking at a different monitor and you're seeing a profile of me. That doesn't mean that I have, and I can even demonstrate for you, this other monitor here that
Thank you.
also has you on it. So
Thank you, sir.
notwithstanding the fact that I don't look like I'm looking at you, I'm looking at you.
Yes, sir. Thank you.
And Ms. Cox Brakefield, why are we here and what's going on here?
Your Honor, before I begin, let me just make one minor correction. Mr. Mendez might not have noticed it, but you said the estate of Grover Larkins Jr. In the
Senior.
case- Yes, it was amended to change that to the correct name.
Okay.
It is Mr. Larkins Senior's estate. Your Honor, this is a claim in small claims or a magistrate court as a claim under the statutory amount based on the entry of a contract to purchase real property in Georgia between the plaintiff and the defendant in his capacity as the personal representative of this estate. The pleadings do not dispute both the plaintiff's claim and the defendant's answer, do not dispute that there was a contract that was entered into, does not dispute that Mr. Mendez did that in his official capacity as representative of the estate. The only disputes I believe we have are whether the contract or Georgia law in general with regard to contracts allows for my client to recoup the expenses beyond her earnest money that she incurred in the due diligence period and actually the period leading any time after the contract was signed in her attempts to purchase this property. And then upon the default of the seller, she was unable to purchase the property and the estate was unable to convey title to the property. Therefore, those are the issues I believe are before the court. Mr. Mendez attached the contract to his answer. We would agree that that is a correct copy of the contract, so I don't think there's any dispute beyond the pleadings on that. And he lays out his contention that we do dispute that the contract does not allow for damages, and even if it didn't, in Georgia, under Georgia law, contract law always provides for damages in the event of a default. Whether or not that's stated in a contract, and of course it is in this instance. So that's our contentions in the case.
Gotcha.
Thank you.
And you don't want no specific performance or nothing like that because I can't give it to you anyway.
No, Your Honor, you couldn't, but I believe Mr. Mendez would agree that he is incapable of specific performance, but my client's not asking for that in any event. My client only wants her damages and to walk away from this transaction made whole for the expenses she incurred.
Okay, thank you.
And of course, also attorney's fees, which are provided for in the contract specifically to the prevailing party should the plaintiff prevail.
Understood. Thank you.
Thank you.
Mr. Mendez.
Yes,
Did
sir.
you want to make some kind of opening statement, but before you do, Ms. Court Reporter,
Yes,
you can hear everything okay?
not everything.
Um,
Trying my best.
I'm going to rely on you to yell if you can't hear sufficient to take down.
Okay,
All right?
all right.
An opening statement isn't evidence anyway, so.
Your
Okay.
Honor, I asked to have the court reporter sworn by the court just in case there is a need for this transcript here in Georgia. Since she's a
Sworn,
court
I've never
reporter.
sworn a court reporter.
I have, but it's been some time. Would you like me to try to do that?
Sure.
Well, I wouldn't normally do it, but because she's not a Georgia, unless, let me ask her, do you have a license in Georgia, ma'am?
No, I don't.
In that event, I think we probably would need to swear her.
Do you have any objection to that?
I don't.
Okay, go ahead. Madam Court Reporter.
Would you raise your right hand? Do you solemnly swear that you will accurately and correctly take the note of the proceedings in this matter pursuant to your training as a certified court reporter in the state of Florida? And would you agree that you're being sworn here in a court in the state of Georgia?
I do.
Thank you.
Okay, my only warning to give both of you is that we're doing this and we're utilizing my tablet at the same time. And because I've been doing this since like 10 o'clock this morning, I'm now down to 31% battery. So my tablet could perish at some point. All right, Mr. Mendez, did you want to make some kind of opening statement?
I do, Your Honor. Thank you for the opportunity. My name is Sergio Mendez. I am the duly appointed personal representative of the estate of Grover Larkins Sr. here in Miami-Dade County. There is what we refer to as a Georgia cabin property, which Mr. Grover Larkins Sr. and Joyce Larkins, his wife, owned since 1982 approximately, and those deeds were of record. The title reads Grover Larkins, L. Larkins, and Joyce Larkins, his wife, and those were of record. The estate placed the property for sale and entered into a contract approved by the Miami-Dade court to sell to Ms. Bond. After the investigation of the title, it was determined by Georgia attorneys that some corrective title work needed to be done with respect to affidavits of descent, and that in fact the estate did not own 100% of the property, but owned, I think, 62% because Georgia doesn't recognize apparently a tenancy by the entirety in this situation, and there were no survivorship rights, so that the three sons who are heirs have, I think, an 11.1% interest. So we attempted to persuade the three sons to sell, and because the three sons heirs can't agree on anything.
Let me rudely, not rudely,
No, please.
lovingly interrupt you, that this is not your opportunity to make your case. This is
Okay.
your opportunity to give me
I'm
an
gonna-
extreme Reader's Digest version of why we're here. And from my point of view, it's almost sufficient to say the plaintiffs are wrong and I don't owe them any money.
I'm going to say that in a little more verbose, but summarily put.
Okay.
It's the state's position that we're not in default. We're ready, willing, and able to sell our interest in the property. It is the state's position that the contract that is advanced by the plaintiff was prepared by the plaintiff and submitted by the plaintiff. And that contract in the default remedies limits the remedies, if in fact the court found that there was a default, to the buyer seeking either specific performance or to terminate the agreement and receive their deposits back, so that the contractual remedies that were drafted by the plaintiff control. So even if there was a default, the remedies pursuant to the contract, which are contractual remedies between the parties, limit the remedies to either specific performance or return of the monies. And the state is happy with both. We will certainly sell our interest in the property of what we have, which I think is 62% according to the Georgia lawyers, or they can have their deposit back. But for damages, it's not called for under the contract, and specifically the statement of claim does not specify what these expenses would be at all. It just has a figure and it doesn't detail what it is or what
Okay.
they would be.
I get it. And you'll have to excuse me while I keep having to flip papers back and forth. Ms. Cox, break that. Call your first witness.
Yes, sir. Your Honor.
Or wait a minute. I'm sorry. Let me just address for the record that we have this package of paperwork that comes from some guy, presumably watching on YouTube, in Florida. And we don't know who this guy is.
We do.
Well, you may,
I do.
but he has not done anything to become a party to this case. There's no motion to intervene. There's no nothing. And it's my understanding that nobody intends to call him as a witness. Is that right?
I do not intend to call
Okay,
the
so,
person that I believe to have submitted that as a witness.
but you're not going to call him, and Mr. Mendez isn't going to call him. So I'm just going to leave this stuff right there in the file. I'm not even going to look at it because he's just a stranger to the litigation and I don't know nothing about it. And he's not a party here.
Your Honor, he is not a party. He's one of the heirs, Grover Larkins Jr.
Well, that explains why he would like to say something.
Yes,
But
sir.
if he's watching, procedurally, he has done nothing to make himself a party to the case. All right,
Honor.
Mr. Mendez, you're representing yourself.
I'm representing the estate. Your Honor, if I may, based upon our defense that the contract remedies are spelled out and they either get specific performance or their money back, may we have a ruling on whether in fact the contractual remedies are the ones, or as Ms. Opposing Counsel seeks to persuade the court that there are additional remedies outside of the contract?
I'm going to give her the opportunity to try to persuade me. Whether that'll be successful or not
Yes, sir.
is another matter yet to be seen.
Yes, sir. Thank you.
And so Mr. Mendez and Ms.
Wakefield will work, Your Honor.
No, Vaughn, raise your right hand. Do you swear the testimony you give me is going to be the truth, whole truth, nothing but the truth, so help you God?
I do.
Okay, call your first witness.
Your Honor, before we do that, I do agree with Mr. Mendez that we would all be wasting a lot of time without a ruling by the court
Okay.
on section 2B of the contract, which you have attached to the defendant's answer in the pleadings before you. And I'm going to read that for the record, if you don't mind, and you can, of course, read along with me.
It's short enough, go right ahead.
Remedies of the buyer. In the event this agreement fails to close due to the default of the seller, buyer may either seek the specific performance of this agreement or terminate this agreement upon notice to the seller and the holder, in which case all earnest money deposits and other payments buyer has paid towards the purchase of the property shall be returned to the buyer following the procedure set forth elsewhere herein. And of course, Your Honor, that's the end of that section. But what I wanted to state to the court in response to what Mr. Mendez said is that if you read this paragraph the way he would like it to be read, let's pretend we're not in magistrate court here. Let's pretend this was a $3 million house, and that the seller goes along, enters into this contract, which does, of course, as it is a Georgia standard real estate contract, which I'm sure the court's aware of. It so states on the bottom of the form. This contract, the seller reports in paragraph 1 that they are warranting that at the time of closing, they will convey good and marketable title. Of course, he's admitted both in his opening statement and in his pleadings that he could not do that. So then let's turn back to the remedies. If the court accepted the interpretation that he's purporting to bring forth, then no matter what size transaction this would be, a seller could allow a buyer to go along, apply for a loan, get a survey, as was done in this case, incur all kinds of expenses toward the purchase of a property, and then just decide, oh, I'm not going to do this, whatever the reason is. And all this stuff in Florida about what he's done and what he tried to do and all that is irrelevant in Georgia, because this is a contract in Georgia that he entered into. Whether he could, would, should have, people may have all kinds of reasons that they wind up not being able to close real estate transactions. But regardless of what that reason is, this remedy is here to protect buyers in exactly the situation my client was in, which is they're going forward right up to.
In that paragraph, it says, following the procedures set forth elsewhere herein. Where is the elsewhere herein?
Well, and first of all, it provides for how the holder of security deposits return it. But in subsection D, there is a
attorney's
provision
fees.
I'm sorry, 2D, just below where we were reading.
Yeah, no, I got it. It's attorney's fee.
There's a provision there that suggests that there is In any litigation arising out of this agreement, including but not limited to breach of contract claims, which is exactly what we have here, between the buyer and the seller, and it goes on to say you can obtain attorney's fees. But that paragraph suggests that a breach of contract claim is permissible. And Georgia law in general in contract claims, certainly anytime a party breaches a contract in Georgia, you have common law rights for damages. And why that would not apply in a real estate transaction, I can think of no public policy reason, no rational reason. that would be the case.
At this moment, the tide is flowing in your direction. I'd still like to know where that following the procedures set forth elsewhere might be. While you're looking for that, Mr. Mendez, if you'd like to respond to her, please do.
Judge, the contract has a plain meaning. It is not ambiguous in any way, shape, or form. It clearly states what the remedies are, and the remedies are two for the buyer, if in fact the seller defaulted, which is specific performance, force me to sell to you, which we're prepared to do. Unfortunately, we only have a 62% interest. After the title was examined, that's what was determined, or get your money back. But nowhere under this contract does it allow for damages. And it's a contract that the plaintiff is advancing. They're saying we had a contract. So if we have a contract, it's not pick or choose. The plain meaning of the contract, it's not ambiguous and inform. Your honors very well. I imagine Georgia law, it tracks Florida law and vice versa. We don't get into contract expansion or adding terms if the terms of the contract are unambiguous. And I would submit to your honor that the remedies here in the Georgia approved Board of Realtors contract form that plaintiff made an offer on or with or through, and we accepted, clearly delineate what the remedies are. There's no room for expansion.
I understand your point. It would seem that the question is whether other payments buyer has paid towards the purchase of the property includes payments the buyer has made to third parties towards the purchase of the property, not necessarily to the buyer or the seller.
Well,
I understand you don't think so.
well, the $142,000 purchase price, it would have to be some money paid towards that purchase price. My understanding, they're seeking for damages, if I heard correctly, for surveys and other things that are certainly not payments towards the purchase price. But in any event, whatever they've paid in as a deposit.
Purchase price. It says paid towards the purchase.
Towards the purchase of the property.
I mean, if the word price was there, I'd agree with you. It doesn't say that. It just says money paid towards the purchase.
It's their earnest money deposits.
I understand you want to limit it that way. Let me ask you a curious question.
Yes, sir.
Are you a lawyer?
I am, sir.
Okay. I suspected so.
Did I sound like a lawyer?
I've been hanging around too many lawyers for too long. But you're a lawyer in Florida and not in Georgia.
Correct, sir. Yes,
Okay.
sir. I'm only licensed in Florida.
No problem. I was just curious. I am at this moment going to say that the contract will allow for damages beyond the mere return of the escrow money, and will allow for money that the buyer has paid towards the purchase of the property, not just the property, the purchase price of the property, because it could have said that and it didn't. Also, the attorney's fees section, I kind of like that argument, that it contemplates breach of contract claims, which there wouldn't be a whole lot of reason for, absent, well, I guess somebody could not return their earnest money, and then you got a breach of contract claim too.
That's actually handled in the section for how to return our mismanagement.
Right, but if they've violated that,
Yes,
then
that's-
that too would be a breach of contract, right? But let me caution that that's not an unlimited license to spend money any way you feel like it. And that there is a near point at which things begin to become quite remote. Now, without having heard any of the evidence, a survey would be something that I think any smart buyer is going to do, because they want to know what they're buying, because what they're buying is a matter of public record. And you're duty bound, at least in the state of Georgia, to get the meets and bounds off a deed and ascertain that there's no encroachments, that somebody hasn't built a pig farm on the lower 40 and trying to do adverse possession with a pig farm down there. So I'm not ruling in their favor. I'm just not dismissing the case, and I want to hear the evidence.
Thank you, sir.
Okay, please proceed. Call your first witness.
Your Honor, I would call Mr. Mendez for purposes of cross-examination. I think a lot of these things are admitted in the pleadings, but just in abundance of caution. You've been sworn, Mr. Mendez. You are duly authorized by the probate court in South Florida that has jurisdiction of the estate as the personal representative of that state. Is that correct?
Yes, I'm sorry, Your Honor. Am I being called as a witness? I didn't quite get Miss.
Yes, for purposes of cross-examination. And maybe if I do this, say something.
Mr. Mendez, did you hear my question?
Not very well. Could you repeat that, please?
I can.
I think the only live microphone is the one here.
Okay, I'm going to talk really loudly and hope he can hear. Can you hear me?
Yes, ma'am.
Do you
If
want
you
to
speak loudly.
If that's acceptable to everybody, I'd be glad to.
bring it up to the podium? That's several feet closer.
I had gone into my head, I had to stay at the table, so I'm going to change it.
Have you
All right, let me see if I can get it. Okay, maybe he's in there. Can you hear me better now, Mr. Mendez?
Slightly better. Yes, ma'am.
Look at him over here. Look this way, because that's where the microphone
So he
is.
won't be able to see me, but hopefully he can hear me. He's
Take
seen
one
me.
step that way.
If you can take one more so I can try to listen and lip read. You're coming forward, but to the side, to the
Yeah,
other side, your other side.
one step back.
There you go.
Now you're in.
Thank you.
Let me put this down.
Fire it up.
Mr. Mendez, you've been sworn as a witness in the case. My question to you is, you are the duly authorized representative of the Larkins estate by the probate court that has jurisdiction of that state, the state of Florida. Is that correct?
Yes, ma'am. Miami-Dade County, Florida.
And you signed the contract that's an issue in this case on behalf of Grover Larkins Senior's estate. Is that correct?
Pursuant to probate court approval, yes, I did.
Yes, the court down there authorized you to do so, is what you just said, correct?
Yes, ma'am.
And finally, you attached a copy of the contract, your pleadings. Do you testify to the court that that is a true and correct copy of the contract that is an issue here today?
Yes, it is.
That's all my questions for Mr. Mendez, Your Honor.
Okay, thanks, sir. Stand by. You'll be back.
And now, I don't know how you want me to deal with Ms. Bond's testimony. If you want both of us to try to come up there, or,
Why don't we do that, because he has the best chance of hearing you then.
okay. Could you please come up to the speaker?
Yeah, stand so you can see yourself on the screen. And let's, what time is my next case? Whoa, let's move it along here.
I'll not say anything else, Your Honor, except for that last case.
I know.
Ma'am, you've been sworn to testify to the court in this matter, is that correct? Yes. And are you the plaintiff in this case, Carol Potts Bond? Yes. Did you enter into a contract here in Georgia for the purchase of property here in Fannin County known as 20 Riverbend Lane with the estate of Grover Larkins Sr. through the representative, Mr. Mendez? Yes. And was that transaction able to be closed? No. Was it your understanding that the estate could not provide marketable title as had been contracted.
Objection, Your Honor. I don't think the witness is qualified to testify as to what marketable title is.
I'll rephrase my question, Your Honor.
Thank you.
Were you able to obtain ownership of this property?
No,
And did you incur expenses during the period when you were waiting to close the property related to the purchase of that property?
I did.
And do you have those expenses enumerated so that you can testify to the court about them?
I do.
Would you, and Your Honor, I can provide a copy of this to the court. These have previously been given. These have been previously provided to Mr. Mendez. There are some slight variations, but the sum total of all of these is less than we alleged, and I'll have the witness explain that.
Okay, Mr. Mendez, this, can you see this?
I cannot, Your Honor. I see a piece of paper. I can't make it out, but I don't have that
Expenses
available.
projected for non-recovery by Carol Cox Bond.
Your Honor,
Forgive me.
I sent a list of expenses to Mr. Mendez back some time ago.
Could you,
That number was larger than the number that is on this document, and we'll explain that as we go through it. But if he has his copy of what we previously sent, he should be able to follow along.
Do you have the copy of what they previously sent you?
no, Your Honor. And the difficulties I pointed out, I think in opening statement, is that none of these invoices or whatever they are were attached to the statement of claim. So it becomes
I
difficult.
understand. She says she sent you this list, summary list.
If she could tell me exactly what day she sent it to me, because I don't have that available. I could certainly search for it. If she could tell me when, excuse me, counsel could tell me when she sent it.
Notes, and that way there won't be any objection.
That's fine. Consider it given back to you in a virtual sort of way.
Ms. Vaughn, if you would, could you tell the court in just a list form with the number, did you, first of all, did you get a survey of the property?
I did.
And who did you get that survey from?
James and Associates. No, Hayes James, we're a surveyor in operations.
And was that survey completed and provided to you?
Yes, it is.
And did you pay Hayes, James and Associates for said survey?
I did.
Court reporter can't hear?
I couldn't hear her answer.
Stephanie, direct your answer that direction. What part did you not hear, ma'am?
Just answer the question again.
Did you obtain a survey for the property?
I did.
And who did you obtain that survey from?
I paid Hayes James surveyors, $2,250.
One second. Can you hear better now? Okay, proceed.
And do you have that survey for this property still in your possession?
I do.
Are you willing, if the estate were to pay you the sum of $2,250 to turn that survey over to them for their use if any need be in the estate matters?
Yes,
And did you have to get an appraisal of the property?
I did.
Oh, we got a stop sign from the court reporter again?
Her last question, I think counsel speaking too fast and maybe it's going in and out and I get some of her sentence, but not all of her sentence. Maybe if she speaks a little slower, I can get everything.
Judge,
Okay.
they're also off camera, so I can't really
Yeah.
make out what they're saying.
Move to the right a little bit or back and to the right a little bit. Okay.
Better. Better.
I have turned my tablet around, so it's not pointing at me and I'm not on camera anymore, but that probably gives them a better microphone. Is that acceptable to everybody?
Yes, sir.
Yes, Your Honor.
Okay, you're talking to this. You're on camera over there, but you can be in profile and that's okay. So don't worry about the fact you're not seeing yourself looking at the camera. Go ahead and I'm going to try and pay better attention to the court reporter too.
And my question was, did the plaintiff obtain an appraisal of the property in anticipation of purchase?
Yes,
And what was the cost of that appraisal?
$2,250.
No.
Oh, I'm sorry, excuse me, appraisal, $525.
And to whom did you make that payment?
That was to Bank of America.
And did they obtain an appraiser?
They did.
What was the role of Bank of America in this case?
They were to be my lender for the loan for the purchase.
And were you required to obtain a credit report for purposes of the loan?
I was, yes.
And how much was that?
$27.31.
Now, ma'am, where do you live?
I live in Black Creek, Georgia, which is about 30 miles from Savannah, Georgia on the coast.
And how did you first learn of the ability of the potential sale of this property?
I found the listing on Realtor.com.
And as a result of that, did you travel here to Fannin County to view the property?
I did.
And when did that occur?
That was on August 1st of 2019.
And did you incur mileage in order to do that?
I did.
And where was that mileage from to?
That was from Atlanta to Blue Ridge because I was already in Atlanta on business. So it wasn't from my
And what was the total amount of that mileage?
$111.13.
And how did you calculate that number?
It was based upon 95.8 miles from Atlanta to Blue Ridge and return at 58 cents a mile.
And did you incur legal fees and title work in anticipation of closing this property?
I did.
And was that after you had come up on August the 1st and looked at the property?
Yes.
Did you enter into the contract after you looked at it on August the 1st?
The contract was actually prior to.
Excuse me, Ron.
Mhm.
Do you know what date the contract was actually entered into?
Oh, I'm sorry, the seller signed the contract on August 29th. My offer was submitted in late July, mid to late July.
So you had an offer outstanding on August the 1st, but it had not been accepted in the form of signing off on the contract by the seller.
The contract had not been signed by the seller.
Now, after the contract was entered into, then, as I started to ask before, did you incur legal fees and title work to proceed toward the closing of the purchase of the property?
Yes, I did.
And to whom was that amount paid?
$250 was paid to attorney Angela DeLorme, who was the closing attorney.
And then after you entered into the contract, did you actually come back to perform the due diligence that you were allowed to do under the contract?
I did.
And how long were you in Fannin County doing that?
From the Tuesday after Labor Day until I believe it was Friday.
And during that time, well, first of all, let me ask you, leading up to coming to Fannin County, did you have to do anything in order to be able to complete the due diligence at the property? Were there any utilities on at that time?
I had requested that the utilities be turned on, and that did not happen, and
Did the contract provide for the seller to make that happen?
it did.
But you went ahead and did that yourself?
Someone from the seller contacted the electric company about it, but when they established the electricity, they billed it to me.
And did you make that payment of electricity that was done at the time you were at the property conducting due diligence?
I did.
And what was the amount of that electric bill?
$83.24.
All right, now, as a result of coming to Blue Ridge, did you take time off from your employment in order to come conduct the due diligence?
I did.
And have you calculated how much that time off work cost you in the amount of lost vacation time?
I have.
And what is that amount?
$1,557.69.
Now, did anyone else come with you to conduct work during the due diligence period?
They did.
And who was that?
That was my husband,
And what was the reason for your husband coming with you for the due diligence?
because he is a tradesman, is very familiar with construction and able to do inspection on the property to determine what might need to be done.
Now, did your husband take time off his regular employment to come conduct due diligence?
He did.
And have you calculated how much lost wages he had as a result of that?
I did,
And what's that amount?
$800.
Now, did you all drive your car to come to Blue Ridge on that event?
We rented a car,
And how much did you pay for that?
$252.61.
And did you have to pay for gas in that rental car?
We did,
What's the amount of that?
$107.49.
And did you have any other incidental expenses related to your traveling here for the due diligence?
We boarded our pets and our meals.
How much was the pet boarding?
Pets was $287.40.
And your meals?
Meals were $162.85.
And did you incur any expenses by any other third parties at the property for any inspections?
We did.
And who was that?
We paid Heritage Pump for a well and pump inspection,
And how much was that?
$75.
And was there any other incidental expenses after that due diligence that you were required to pay as a result of the contract?
Yes.
Can you explain that to the court, please?
The appraiser required that the storm shutters that were on the residence be removed in order to complete their appraisal. And so they were removed and then subsequently replaced.
And did you obtain permission from the seller in order to conduct that
I
work?
did.
And how much did that work cost?
$96.
And the grand total of all these costs that you've incurred?
$6,585.72.
That's all the questions I have for Ms. Bond, Your Honor.
Okay, stay where you are. Mr. Mendez, your witness.
Your Honor, before I do that, if I may, I'd like to move for a judgment of involuntary dismissal. The evidence is insufficient to sustain the claim in that no evidence was introduced concerning actual payment or any invoices that are submitted to the court. There's nothing that's been introduced other than testimonial evidence by Ms. Bond to support her statement of claim. So we have no invoices, no proof of payment, nothing that's been introduced. And I would suggest to the court and urge the court to enter a judgment of involuntary dismissal based upon the lack of evidence.
Motion denied.
Thank you.
Your witness.
Ms. Bond, good afternoon.
Can you hear him okay? Okay.
Ms. Bond, was the contract that you entered into with the estate of Grover Larkin Sr. subject to financing?
Let me interrupt you right there for 1 second. I noticed, and I was going to inquire, Mr. Mendez, I'm going to move one step further up the chain than you're at. On paragraph 7, which is on page 7 of 8, the conventional loan contingency exhibit B box is checked. And I don't have a copy of that. Is there a copy of that?
Where are you looking? I'm sorry, Your Honor, I lost you. Where are you referring to in the contract?
Page 7 of 8 of the contract attached to your answer.
Your Honor, I might be able to fix this by asking an additional question. Ms.
Now, I
Bond.
just want to know if this page exists. It says that you've got an exhibit A and an exhibit B and an exhibit C to the contract. A is the closing attorney to act as the holder of the earnest money. B is the conventional loan contingency, and C is the lead-based paint exhibit. Where's B?
Your Honor, my client has all of those attachments in her email that we could send to you and to Mr. Mendez. It might take a minute to find them, but my question would be if any of those are really relevant here. She can answer his question about financing if that would help.
Well, the question at this point is that available? I'd like to see it.
Yes, Your Honor, it is available. We'd be glad to submit
Mr.
it.
Mendez, do you have that?
I do not, sir. I just checked the contract that I signed, and none of those addenda do I have, or did I sign,
Uh,
as far as I know.
Have you got it in an electronic form? That I
Yes,
can-
and Your Honor, my client indicates that that was emailed to both her and to Mr. Mendez.
Well, let me see what you've got. Mr. Mendez, I want to see what she's got so I can see if I can look at it.
She's gonna
Yes,
have
sir.
to email and find it, Your
Go
Honor.
ahead.
It's gonna take a moment. Go ahead.
I mean, the contract indicates that, you, get on. Do it. Is that her iPad?
It's mine, but she would just log into her email.
All right, well, let's do it. I mean, let's. Keep me advised. You know, you have one case that starts to fall behind everything else. Ladies, today would be nice.
Well, Your Honor, we weren't anticipating having to find this. It's hard for, she did not bring her computer, so she's got to.
I understand. I'd like Mr. Mendez to be able to continue asking questions.
That
so
would
that
be
we can-
fine. That would be
Okay.
fine. I mean, I'll look in the papers. Yeah.
Your
Go ahead.
Honor, the basis of my question is that it's the estate's position that this contract was not subject to financing, and there go the expenses that are claimed in relation to the loan should be disallowed. But since that is that
Argument.
portion of the contract is not before the court, I can't inquire further unless Your Honor wants.
You're the one that attached it without the exhibits that the contract calls for.
Well, Judge, I did file it as part of my answer, but respectfully, I think it's the plaintiff's burden to attach a copy of the contract upon which they're alleging a default.
Well,
I
you did it, and they didn't want-
referred to it in my answer
You see,
because of the contract remedies that we sought to urge the court that they were limited. But I think it's a plaintiff's burden, respectfully, sir.
Well, it might be the plaintiff's burden. Perhaps they didn't look at what you attached carefully enough to realize that what you attached was partial and incomplete.
Well,
But nonetheless, go ahead with your questioning.
Ms. Bond, has the estate of Grover Larkins refused to sell its title interest to you?
Only by virtue of the fact that they did not meet the closing date in the contract.
Ms. Vaughn, the estate of Grover Larkins did not refuse to sell its interest in the property to you. I'm sorry, sir.
That's not a question.
I thought I was cross-examining her, sir.
Right. Even in cross-examine, the inflection at the end has to go up because it's a question.
Okay, yes, sir.
Now, let me put it this way. Mr. Mendez, you're a swell guy. I like you already. However, don't go down a long line of questions that the estate's willingness to sell 62%
Yes, sir.
is going to be performance with this contract.
Sir, I understand that, and I'm not trying to be disingenuous, but I do want to support our affirmative defense that the state never refused to sell this property.
Well, the estate
The estate.
was incapable of delivering good and marketable title because it didn't own it all.
Well, I believe it's not only that, sir. I believe there's another issue of title which I'd like to question Ms. Bond on.
Could the estate deliver good and marketable title?
The estate could not
Okay, then
deliver.
let's not go down this road too far because
Okay.
that was contractual duty.
Yes, sir.
Let's move on.
Ms. Bond, the payment of the amount that you testified to with respect to the survey, was that survey required by your lender?
I do not believe so. The closing attorney required it.
And who would that closing attorney be?
Angela DeLorme.
Angela what?
Spell the last name.
DE, capital LORME.
Thank you.
As far as the appraisal, did you pay sums for an appraisal?
I did.
And who required that appraisal be made for the property?
Bank of America, my lender.
Your lender? I couldn't hear you.
Yes, that's what she said.
Okay. And now, with respect to the sums that you're claiming concerning lost wages, those were not payments that you actually made for the purchase of the property, correct?
Mr. Mendez,
Yes, sir.
let me cut this short. I'm not giving it to her.
Okay. As well as I can go through the categories, Your Honor, as far as meals and lost wages and boarding and those things. That wouldn't be payments towards the purchase of the property.
I appreciate your argument. Next question.
What was the total amount of the legal fees and title work that you actually paid?
$250.
Okay, and the survey, you actually paid an amount of $2,200?
$2,250.
Do you have a paid invoice to support that amount?
Yes,
Do you have it to present to the court?
I do.
May we see it?
Just pass the whole package up here.
Well, does he want everything up at one time? You just disallowed some things that.
Well, no, pass the whole package and I can filter through it. I'm trying to, we have a 3 o'clock trial schedule. You're not in.
Judge, what I found from counsel was a summary of these expenses,
Right.
but I don't have any copies of these actual invoices. And I also, they didn't even seek to introduce them into evidence. So I'm at a loss.
Well, here's the bill for the appraisal. Here's the, I don't know what this is.
Your Honor, that is the appraisal and the credit check in one receipt.
Okay. 2250 on the appraisal.
No, I thought that was the survey, sir.
I'm sorry, you're right, the survey. Title examining fee from the attorney, $200. Title commitment, $50. Application for membership at Blue Ridge Mountain EMC. Be careful what you wish for. A couple of Blue Ridge Mountain EMC bills, and some bank statement information with Heritage Pump Service for $75. I mean, they're here. Can we get Danetta to scan these and email? Do we have your email address, Mr. Mendez?
Your assistant, Miss Israel, did communicate with me. Yes, sir. I believe
We
she
must
does.
have, because we invited you to the Zoom.
Yes, sir. Thank you.
I'm just
Yeah,
gonna,
the most gracious invitation. Thank you.
always a pleasure. She should have his email address. If you'll ask her to please scan those and email them.
Judge, if I may ask a question of the court and hopefully try to streamline this procedure.
Excellent.
Did not find, I thought it was, do you want me to answer your question?
Well, I ended up multitasking inadvertently.
It's hard not to.
You did not find contingencies.
I have not found it in my email at this
Okay.
point. We can get that for the court or Mr. Mendez after this hearing. It seems like the only issue he's got is over the fact that there was financing, which my client has admitted.
Well,
The lead-based paint and all that, I don't think's really.
the answer to my question is no.
Yes, sir.
Okay, Mr. Mendez, you were about to say something and then I
Well,
had,
Judge, I understand you have another trial and certainly not in derogation of my client's due process rights, but I would like to have a better idea as to what are those invoices that the court is actually considering. I understand the court is not considering lost wages or meals or pet boarding or anything of that nature, but if
You've
our
kind of got
contention,
where I'm going.
Yes,
You've
sir.
got, you've got where I'm going.
yes, sir.
You are correct.
And I think it's important that if we do not have a financing contingency part of the contract, then those expenses that were incurred with a lender, we would submit should be disallowed.
I understand that's your submission. The contract refers to the financing contingency. Even though nobody's bothered to actually find the page that has that exhibit, the contract on its face says there is one. You're right now, you're doing about 50%. That ain't bad.
In Georgia, I think I'm doing pretty well.
All right, so let's carry on here. Anything else for this witness?
Just give me 1 second, Your Honor. I don't have anything further.
Very good. Anything else for this witness? Please say no.
One question, Your Honor.
Okay.
Ms. Bond, was your loan application approved by your bank?
Yes,
Were you prepared to go to closing with everything that you were required to do by the contract complete?
That was two
That's
questions.
two, you're right, I apologize.
I
Oh,
can't,
that's two, right?
I may not, I may be a lawyer, but I can still count to two. And I just
I have
minimized.
nothing further.
Okay, she's got nothing further. Any other witnesses?
Your
Please say
Honor, I
no.
would like to testify about my attorney's fees, but other than that,
Okay, that means I gotta find my notepad again. All right, go ahead.
you want to swear me in? Your Honor? I'll swear
No,
myself.
you're an officer of the court. I'll just have you jailed if you lie.
Okay, thank you, Your Honor. Well, not for that part. but for my- Your Honor, my name-
Deputy, you got cuffs?
My name is Kathy Cox Brayfield. I am a licensed member of the State Bar of Georgia. My state bar number is 192, I believe. I have filed the pleadings in this case. I have spent at least 10 hours.
I didn't hear you when he coughed.
Court reporter can't hear you.
I'm sorry, I turned away.
Well, and I took this back down because I thought we were done with that. But go ahead, louder.
Your Honor, my name is Kathy Cox Brayfield. I'm a licensed member of the State Bar of Georgia, State Bar number 192292. I've been practicing in the state of Georgia since 1984 continuously. I have vast litigation experience. I am here for the plaintiff. I have spent at least 10 hours on this case, emailing with the closing attorney to find out documents, to talk to Mr. Mendez, to try to work on the case, emails back and forth, not to mention all the emails I read yesterday in this case. And the court time today, I would ask for 10 hours of attorney's fees plus 2 hours today, getting here and doing the hearing. My out-of-court time, I would ask for $150 per hour. I believe that's very reasonable in this area for attorney's fees, and in-court time at $200 an hour for 2 hours today.
So 10 hours, you're asking for 10 hours at 150
And 2
and
hours.
2 hours at 200.
Yes, Your Honor.
And that's a ordinary and reasonable rate for an attorney of your education and experience handling matters like this in the local area, right?
Yes, Your Honor.
Okay.
That's correct.
Mr. Mendez, did you want to ask her any questions about her statement in her place?
Well, Your Honor, and forgive me, I'm not a Georgia lawyer, but I would submit that we would need in evidence a more detailed statement of services as to actually what was specifically done and for what time. Her hourly, Ms. Breakfields, excuse me for saying her, hourly rate is certainly extremely reasonable. The amount of time for filing the statement of claim and coming to court seems to be excessive, but I'll leave that to the court.
Okay.
But
All right.
my contention would be that this is,
So-
people have tried to drag me into the Florida litigation, and that's taken a lot of my time.
So I will take my question to you. The answer is no.
I do not have a bill prepared.
No, that was.
I would have preferred a yes, but thank you.
Well, you don't have any questions for her?
No.
Okay. Anything else?
No, sir.
Mr. Mendez, would you like to present anything else?
No, sir. I'd like to make a brief closing statement if you allow me.
As long as you adhere to the use of the word brief. And you'd like to reserve your final closing remark, wouldn't you?
I will reserve.
I thought so. Okay. No, we're going to be done here in a minute.
Okay.
Yeah.
Thank
Is there still only one side here?
Yes.
Well, that'll only take a second.
Well, that's why he said he could just
Oh, and it's the plaintiff or the defendant?
plaintiffs.
Well, if he wants to strike the answer of the defendant and give him a default judgment, sure. Because we've got another one in 15 minutes, right?
Yeah, so he's,
Knock it out.
okay.
Okay. All right. I'd like to remind you that the important word there is brief.
Yes, sir.
Please proceed.
So in that, Your Honor has ruled that the contract allows for a breach of contract damages. I won't belabor that point
Thank you.
respectfully. Your Honor, as far as the evidence presented for these payments that were made pursuant to the contract has to be made towards the purchase of the property, we would submit that there is insufficient evidence that has been presented as far as any documents that were introduced into evidence that would prove and evidence that in fact there was an expenditure and there was a payment subject to being returned to the buyer pursuant to the contract. So there's just a lack of documentary evidence that is required to support this claim. Additionally, there is nothing in the record, and we submitted was the plaintiff's burden to introduce a full and complete contract, which they haven't done. And I understand Your Honor may feel that, or feels rules that the check mark on the last page is a financing contingency, and respectfully, we disagree. But with respect to the amounts that are claimed that have been paid, there's simply a lack of evidence to support the claim for damages, and we would submit that a judgment should be entered in favor of the defendant and that no attorney's fees be awarded to them.
Gotcha.
I submit the case to the court.
Thank you. Okay. I think I get to think too.
Yes, sir.
What's the status of the earnest money?
It has been returned
Okay.
except for the payment of the part that was due for the title search by the holder, which
The
was,
$1,000 is not an issue.
no, we didn't raise it. We haven't asked for it. It's
Okay.
been dealt with.
It's all taken care of.
Yes.
Okay. I think that the contract, I think that there's no dispute as to the facts regarding the performance of the contract, and that the seller could not deliver good and marketable title due to the partial ownership interests of other family members of the deceased. And therefore, the good and marketable title could not be delivered even subject to the restrictions, which do not include recalcitrant family members who don't want to sell. My battery is running low. I might want to, how do you let me know? Wave if you lose my microphone, and somebody keep an eye on a camera so that we can switch to some other form. I think that the contract does call for damages with respect to payments the buyer has paid towards the purchase of the property. It doesn't say the purchase price, it's towards the purchase. And I'm not really troubled with the fact that we ultimately can't find a copy of Exhibit B because the terms and conditions of Exhibit B are not in dispute and are not part of the dispute between the parties. The contract on its face says there's a financing contingency. and that contingency was never invoked to terminate the contract because of financing unavailability. And I'm old enough and I have enough gray hair to know that that means that they talked to a bank and were driven through Hades by the bank doing this and doing that before they were approved to buy. I think that those are expenses by the buyer that are contemplated for by the contract. On the other hand, I think some of these other expenses are just too remote. We're not going to pay for the dog sitter while you do your inspection of the house. Not going to happen. And stuff like that is just too remote. If you don't want to have a dog sitter, bring your dog along. It doesn't say in the contract you can't have a dog with you while you do this stuff. And I say that kind of tongue in cheek, and I don't mean anything nasty by it, but it's too remote. I'm going to give you the 2250 on the survey, the 525 on the appraisal, the 2731 on the credit report, no mileage, the 250 to the closing attorney. I'm going to give you the. Are you keeping track of this?
I would say yes on the attorney's part.
On the attorney's fees to the closing attorney, yes.
Yes, I am keeping track.
Okay, the 8324 to the electric company, I would ordinarily say no to, but the contract is clear that it's the seller's obligation to have the utilities on for the buyer, and they didn't. So in order to have the electricity on, and you can't look at property in this county without having the electricity on because everything is all electric. And I said, be careful what you wish for with Blue Ridge Mountain EMC. And that's because I'm on them and I know they're the hillbilly electric company where the power's going out every 10 minutes. So good luck with that. But I'll give you the electric bill. I'm not going to give you the lost wages. I'm not going to give you the car rental or the gas or the pet or the meals. I will give you the $75 on the well and pump inspection and the $96 to take the storm shutters on and off so that it could be, was that appraised or evaluated?
It was so the appraiser could
Okay,
perform as he was required to do.
okay. Not unreasonable. So quick as a flash, figure out what that adds up to.
How much was the electric, Your Honor, if I may ask?
$83.24.
I'm gonna have the
So-
account.
It's the survey, the appraisal, the credit report, the title, the electricity, the well pump, and the shutters. Is that correct, sir? I hope.
I think, let's say it again.
The survey, the appraisal,
Survey.
the credit report, the
credit-
title of 250, the electric, the well pump, and the shutters.
Yes. Now I'll address the attorney's fees. Ordinarily, I would say no to attorney's fees.
Hopefully I didn't do anything wrong to make you say yes.
I think we lost him.
Judge, we lost you. We lost him, right?
Yes.
I can't hear you. I can't. We can't hear Judge Altman. We lost his audio in the hearing. Okay. Yes, okay. He says we're trying to fix it. Okay. Thank you. Connecting.
You are using computer audio.
I got you. I can hear you now.
And the
Sorry.
court reporter, you can hear me now? All right. Okay, so where I was at was, I'm sorry, my tablet died of old age.
No, I have the total.
Okay, ordinary, I wouldn't ordinarily award attorney's fees in this case, but the contract is clear that in any litigation, including but not limited to breach of contract claims between buyer and seller, the non-prevailing party shall be liable to the prevailing party for its reasonable attorney's fees and expenses. And while I might have a question or two about whether or not 10 hours is really reasonable, I would have thought that even $300 an hour would have been reasonable given what I know for attorneys that entered the market in 1984. So you're really getting it at half price when you're at $150 an hour. And the $200 an hour for court time is certainly reasonable. And it's not her fault that we have these car accident cases that just thrown on and on. So I'm going to go ahead and give her the 10 hours at $150 and 2 hours at $200 because that's what the contract says. And that grand total amount is?
The damages are $3306.55, and if I understood correctly, the attorney's fees are $1,900, and those should be delineated separately in the court's judgment, I believe.
That's fine with me. And Mr. Mendez, anything else?
Judge, I see the attorney's fees would be 10 hours at 150, which is 1150, and 2 hours at 200, which is 400. So that makes it
Bad math.
1550.
Bad math.
And then I didn't
10
get
times
the figure.
150 is 1,500.
1500. And the damage total, just so I know, I'm sorry.
Well, 3306.55 is her math. 1,900 on the attorney's fees is good math, regardless.
Double check the damages, but Mr. Mendez is welcome to double check them as well.
You're welcome to use your own calculator. She represents her proper use of the calculator to me.
The attorney's fees, I think, is maybe off. 10 at 150 is
1,500.
Oh, that's right. I'm off. Sorry. That's why I went to law
That's
school.
why you have a law degree instead of a mathematics degree.
Exactly.
Right. I've done that myself.
Ms. Vaughn has the calculator. There's no reason to doubt her. She's an officer of the court and a fine lady.
Very good. Anything else?
No, Your Honor.
Will we prepare a judgment or do we want her to do it? Do you want to do it and email it in? I'll sign it.
Sure.
If you'll do it before Thursday, I'll sign it on Thursday.
I will have it here Thursday, either by email or I will get it here in person, one or the other.
Thank you, Mr. Mendez. You're a very competent attorney. I appreciate your efforts. Good job. Sorry.
One question before we close. Do you want me to include your findings of fact in the judgment as well as?
Very, very, very briefly.
Will do.
Okay,
Thank you.
very briefly.
I will do my best.
Thank you.
Thank you. Have a
Thank you.
great day, sir. Thank you.
You too.
If y'all not done, your 3 o'clock is done.
3 o'clock is done. Thank you, sir.